Hello and welcome. I'm Peter Afrasiabi, and I filmed this program a few years ago. The Curious Lawyer, Dog Law. I've reviewed it, and I can confirm it is still current, so please enjoy it. Hello and welcome to the Curious Lawyer series. So much of CLE can be boring, oppressive, tedious, but it can be critical because we have certain practice areas and we've just got to stay on top of the basics, the fundamentals of whatever it may be. But CLE can also be fun, and it can be light and it can be whimsical, much like reading. Sometimes we just have to read dense, serious stuff, but we can also read for fun sometimes and just read a light romantic comedy novel or a mystery novel just for fun. Well, this CLE series is kind of like that. It's designed for the curious lawyer who wants to just learn something new in a different area, have a fun new experience. It's light, it's whimsical, and you learn something really fascinating, new, fresh, and different, something you'd probably never thought about. This one, Dog Law 101, Woof Woof Law 101 as we put it. You're going to learn all things dog in the next hour. And it's actually really fascinating because our furry friends, our canine pets, really touch upon myriad legal regimes. And it's remarkable to see how dogs cut across constitutional law, criminal law, tort law, divorce law, even disability law. And so you'll get some fascinating insights into these myriad different legal regimes. And the whole time we'll be talking about dogs and how dogs exist and function in our legal system and how our legal system treats them. So if you have your own dog, sit back, relax, have your cup of coffee, pet your dog, and let's get going on dog law. First question we want to look at on this slide is, why dog law? Well, as you see from some of the data here, it's estimated that there are 78 million dogs in the United States. Approximately 44% of all households in the United States have a dog. That comes from the American Pet Products Association. It's data from 2015 and 2016. Other data from National Geographic shows that 90% of owners consider their pets part of the family. And that becomes a significant concept that starts undergirding some of our legal regimes that we'll be talking about soon. Studies also show, remarkably, that more than 80% of us would likely risk our lives for our pets. And as of 2013, we spent $55 billion on the animals that share our lives. One fascinating study, and this is reported in the Villanova Law Review, in 2002, has found that over 50% of the people surveyed reported that if they were stranded on a desert island, they would prefer to have their pet than a human companion. So this shows our dogs, our pets, they mean a lot to us. There are so many of them in society. Most of you watching given this data probably have a dog or a pet. So let's learn about dog law and why we should learn about dog law. Well, as you see on the next slide, dog law intersects with multiple legal areas. And we're going to go through these. It intersects with our basic regulatory code law, the police power of the state in terms of owner responsibilities and duties. And this is sort of a subset of negligence law. It intersects with criminal law in terms of how we treat our dogs and what are the legal limits of what people can do with their dogs. It deals with even trespass law in terms of trespassing dogs and what the consequences are for the dog owner, and the trespassee, so to speak. It deals with the obvious in terms of tort law and negligence law, in terms of dog bites and who's liable and how much for if a dog bites someone. But it gets kind of fun and interesting because dogs have always found themselves in divorce law too, and there have been dog custody battles that we will see. We also see dogs intersecting with constitutional law. Yes, you heard that right. If the Fourth Amendment and its warrant provision is violated and at issue as police come in to take a dog without a warrant, the Constitution and a constitutional analysis suddenly applies to the warrantless removal of a dog. And we'll look at that too today. We also have property law concepts in terms of the nature of what is a dog as a piece of property. But also then dog impounding and the police power of the state to impound and ultimately kill dogs if they're not collected. We look at tort law again in terms of wrongful dog death liability. the liability that people may have if they kill someone else's dog. We'll look at more criminal gambling law in terms of dog fighting and the legality of dog fighting and gambling upon it and creating enterprises built upon dog fights and how that intersects with our criminal laws. And disability law in terms of service dogs. Dogs are a very important part of disability law. And ultimately, for fun, we'll even talk a little bit about copyright law, which is where I practice, and we'll ask if a dog selfies itself by hitting the button on your phone, does the dog have a copyright in that photo? So it's going to be a fun walk through a whole bunch of different legal areas that our countless millions of dogs inhabit. So let's start with the beginning precept. How does the legal system see dogs? And so as you see on this slide, we've got our cute little dog sitting in its cup, but the question is, how does the legal system see that dog? Generally, dogs are mere property by operation of state positive law, enacted law by the legislatures of the states. And so as property, dogs are subject to myriad legal regimes, just as all property is subject to myriad legal regimes. And so legal codes and laws, whether it's enacted law or common law, that deal with and address the demand for and the need to respect private property, engraft onto dogs as people's private property. And reciprocally, laws that regulate private property, what you can do with private property, also engraft onto dogs. And so at root, dogs as property are subject to the general police power of the state. One exemplary code you see here quoted, this comes from Oregon, and it's the same in basically every state, but this is Oregon's version. In section 609.020 says, dogs are hereby declared to be personal property. Now, let's go to the next slide, because this is an important point. As property, dogs become your property at the moment of purchase, literally at the moment of purchase. And here's a case where someone found that out the hard way. This is a 1942 case from California called Menches versus Inglewood Humane Society. And these were the facts. The plaintiff victim went down to the local Humane Society and purchased a dog. And literally less than 10 minutes after buying the dog and leaving, was bitten by the dog. And so the owner said, I'm going to sue the Inglewood Humane Society, and sued them, and negligence for the dog. And the court held, nope, it's not their fault. That was your property. Your dog bit you. Their dog didn't bite you. And so as the court held there, the fact that the ownership had been vested in plaintiff only 10 minutes doesn't minimize or alter the significance of the acts of the acceptance of the dog and the payment of the required fee. Their title to the dog became vested in plaintiffs just as conclusively as though they had housed him for more than 3 years and had asserted adverse title to him. This is a really important principle. It's sort of self-obvious about property in some sense, but it's also an important principle that animates sort of the historical way of looking at dogs as property. And a dog as pure property is a concept that is evolving and changing in the law. And so on our next slide, we're going to look at some more 21st century developments that are afoot. And here we can see a case involving a defendant who was convicted of animal neglect after failing to feed her dog. And this dog's name was Juno. That's not a picture of Juno there, by the way, but it's the same kind of dog that Juno was. So what happened here is police came along, they removed Juno, tested Juno's blood, because of some animal neglect that was perceived. And there was a big battle about, whether the state had the right to test the blood to figure out if there were medical conditions involving malnutrition. And the defendant was then prosecuted in a case and wanted to exclude all the blood results from her dogs, from Juno, the dog. And that was denied by the trial court that said, no, you don't get to exclude that stuff. And the argument was, it's my property, you shouldn't have analyzed it and looked at it, and so I want it excluded. The Court of Appeal actually reversed and said, yeah, that's right, the dog's was her property and you don't get to exclude it. And they found it an intrusion into the defendant's right of privacy because the dog was merely a piece of property in effect. Now, This then goes to the Supreme Court, and the Supreme Court in this Juno case had a very important issue to address, and that is, does the owner have a protected interest in her dog's blood? Because it's just a dog as a piece of property, and upon being seized, it would be the owner's property, and the owner has some sort of a privacy right in that dog's blood. And the defendant argued to the Supreme Court in this case, and this case came out of Oregon also, that a dog really is just a piece of property like a stereo. And so if it's to be seized, it can be examined and looked at, but that really should be it. And the Oregon Supreme Court actually held differently. What the Oregon Supreme Court said in the decision, and here's a quote, is that dogs are sentient beings capable of experiencing pain, stress, and fear. And so they're not just simply property that can be looked at through a property lens or a property prism. These are sentient beings that have feelings. And so the Supreme Court ultimately concluded that no, the taking of the blood sample and the analysis of it was perfectly okay. And the defendant's property type argument to justify retaining control over the blood sample from the dog was rejected. And it was squarely rejected on the theory that the dog was a sentient being and it's something different to just property. And this is very, very important. And other cases have echoed it in other regimes too. And this is sort of part of a developing animal rights body of law developing across really myriad legal jurisdictions in terms of our shifting concept of, as a society, as a collective body politic, of property and protection for animals and where animals fit into our property schemology. The next slide, you can see the actual holding from this case. It's State versus Newcomb. It was 2016 from the Oregon Supreme Court again. And the court squarely said, in these circumstances, we agree with the state that Juno is not analogous to and should not be analyzed as though he were an opaque, inanimate container. Juno's contents were the stuff that dogs and other living mammals are made of: organs, bones, nerves, other tissue, and blood. And so, as the court noted, while a dog is personal property under Oregon law, a status that gives a dog owner rights of dominion and control over the dog, but Oregon law simultaneously limits ownership and possessory rights in ways that it does not for inanimate property. Those limitations, too, are reflections of legal and social norms. And so this is obviously a very important idea, and it's a very important case. It's really a seminal case in terms of talking about our dogs in that way as sentient beings and the shifting nature of how we really should be looking at them. So if we turn over, we're now on the next topic, which is dog ownership, where dogs meet regulatory law. And there you see a picture of someone's nice pooch next to an animal law book. So this gets into the basic body of regulatory law that deals with dog ownerships, and this is where we intersect with positive regulatory law. And here on the next slide, you can see the basic owner obligations that exist for those who own a dog. There are licensing rules that come from states or counties. Often they're even city-driven. There's vaccination laws that most states require certain vaccines for dogs. Many cities and counties have leash laws. There are safety laws relating to the condition of the dog and dangerous, vicious activity type related laws for dogs. There are state impounding regulations that apply to loose dogs with notice requirements to the owner if the dog is tagged. There are poop scoop laws that deal with, laws of local cities and counties regulating the need to clean up after one's dog. And here we have an example from Orange County, California. And this is enacted by Orange County, California and its local codes. And the county provides that a person having custody of any dog shall not permit, either willfully or through negligence, a failure to exercise due care or control, any dog to defecate or urinate upon any public area, private property, county park, or beach. The person having custody shall immediately remove any feces deposited by such dog. Pretty broad laws, you see, in terms of poop scoop laws. So the point being, our dogs are at first, at the first level of the law, regulated by this body of regulatory law in terms of owner obligations for this dog, this piece of property, sentient being, our animal, in terms of how it is supposed to be controlled and managed by us and conducted in society. critically here, under really the laws of all jurisdictions, the states can legislate here, but they generally allow the city and county to legislate themselves for their own local needs based on that county or that city and that community's local preferences for dogs. So while it is a matter of state law, the states actually really defer and don't legislate heavily in this area, really letting it be regulated at the very, very local level based on dog owners. So there's a massive local level of body of law of dogs that you need to know if you're going to be owning a dog or if you're going to be traveling with your dog. You really need to be aware of the local regimes that govern dog laws. The next slide is kind of a fascinating aside, and this shows that not only is it important to respect laws, but you should also respect just kind of the custom of the community you're in. And so this is an email that came from my community in Laguna Beach, California. There's this sort of community network of people in a whole area of town who can email with one another about things that are going on in the town, like if they've seen a thief or something like that, whatever. This one, the names have been removed to protect the innocent or the guilty, so to speak. But this one involved a very upset person whose dog had defecated outside. And as you can see, the email posted on this public email exchange was, "To the woman walking her white medium-sized poodle last evening at 7:20 wearing a red shirt and white pants walking up Legion Street, who didn't pick up her dog's deposit and who ran away towards the high school when I yelled at you, the SHIT is still there. Feel free to come back and prove you're worthy of owning a pet and pick up after your dog. I'll be looking for you if you dare walk your dog on the street again." So you can see, customs are very important too, and people can get very irate about violations of poop scoop laws. So let's move to our next major topic, which is getting into negligence law, and this is dog bites to humans and reciprocally human injuries to dogs. So here are the dog bite general rules on the next slide. The owner is virtually an insurer of the dog's conduct, and that comes from an Arizona case, and it's reflective of statements in most jurisdictions. And so there's a bit of a split across the nation in terms of dog bite rules. There's two basic rules at play. There's a strict liability rule and there's a one bite rule. And so we're going to look at both of them. The general strict liability rule is that if the plaintiff was illegally allowed to be where she was and she did not provoke the dog, then the dog owner is liable if the dog bites the plaintiff, period. So if your dog bites someone and that person was where they were allowed to be, irrespective of your dog's prior behavior and anything, you're simply liable per se, strict liability. Now, at common law, historically, there was what's known colloquially as the one bite rule, which was literally that. Dog gets one free bite. Regardless of owner knowledge, any dog gets to bite one person once and owner doesn't have to be held responsible. Liability would attach once the bite had occurred, and then one has knowledge, and then one's supposed to conform their dog and their behavior and regulating their dog to protect future people. Now, that one bite rule at common law has really been modified by modern one bite negligence standards to be the following rule. If the owner has reason to know that a dog may have dangerous propensities, then even the first bite can yield liability. So there is no per se one bite rule. Now, if there's no knowledge at all that your dog would ever bite, it's the kindest, gentlest little puppy, it's never bitten anyone, it's never snarled, growled, barked, or anything, then yeah, you may still have the benefit in those jurisdictions of the one bite rule. And as we look on the next slide, you can see this state-by-state analysis in terms of the breakdown between strict liability and one bite rules. And as you can see, the vast majority of states, or maybe not the vast majority, but certainly the majority of states, are strict liability regimes. There's a handful of states still that have retained a one bite rule, and really all of them, the one bite rule is the modified version that takes away immunity if there's knowledge or a basis to know that your dog has a propensity to perhaps be violent or aggressive. On our next slide, if you're in a dog bite situation, you have to think about, okay, I'm a defendant, what are my defenses? Well, there's traditional affirmative defenses, and then there's a very unique one to the area of dog law. The traditional ones, of course, are trespass. the person was trespassing on my property, they had no right to be there, and the dog bit them. And so that acts as an affirmative defense in a dog bite case. Another defense is provocation. My dog bit you, but you provoked my dog by doing some sort of conduct that provoked the dog. Now, in most laws and in most legal regimes across our states, that provocation defense does not apply to young children. So, young children, which is generally, when you look at the case law, 2, 4, 6, 8 years old, something like that, is deemed not capable of sort of provoking a dog. But this is really important, and that is that provocation doesn't engraft upon emancipation. 8, 10, 12, certainly teenagers, they have the capacity to provoke and know better, and so the law doesn't let them get away with the benefit of claiming, well, I'm 16 years old, I'm a minor, so I can't provoke, right? Something like that. So no, they can provoke, and it won't be, or it will be an affirmative defense if the kid's a little bit older. There's also, of course, the assumption of risk defense, which makes sense. I mean, if someone walks up to a dog on a public street and, you've got 2 or 3 Rottweilers or something, and someone comes up and starts hugging them and, rubbing them and pulling their tail or something and get bit, they assumed a lot of risk and probably provoked. Now, the unique affirmative defense here, if you find yourself in the realm of dog bites, and this is just a fascinating, quirky rule from the common law that is still law across all jurisdictions, it's known as the veterinarian's rule. And as it turns out, it's broader than the veterinarian, but you'll see. The rule is that people who make a living handling dogs are considered to have assumed the risk of being bitten while the dog is in their custody or under their control. That's just as a matter of law. And so the rule applies obviously to veterinarians, hence its name, but also all other people who take control of and custody over dogs. And that includes dog groomers, dog trainers, those who transport dogs, dog walking services, pet shop employees, and even paid house sitters who are sitting with dogs. So the veterinarian's rule is very, very broad and a very, very important defensive rule in a dog bite situation. On the next slide, you can see a bunch of verdicts, and these are just simply verdicts. We're not going to go through all of them, but you can look at them at your own leisure, that really show the staggering, types of verdicts that have come from dog bites cases. Some being as low as 25, 40 grand, some being as high as multi-million dollars if the dog has killed or permanently damaged someone, including liability in cases for building owners where, the building owner didn't, necessarily take care of the building enough to protect other, certain tenants from other tenants' dogs. And so liability can engraft upstream in a negligence scenario, which requires you, if you have clients, for example, in an apartment building business or housing communities and whatnot, to make sure they have proper insurance limits and they have situations and rules in place to deal with dogs, because some of those verdicts are pretty staggering. Dogs can obviously cause great damage. So the next page has our practice pointer tips. And here, as a dog owner, the tips are: you should notify your carrier if you buy a dog, your homeowners and carrier, and you should seek coverage. You never know what may happen with your dog, and having insurance coverage is of great benefit. You should also follow your local rules, jurisdictions, and your local jurisdiction's laws and standards regarding vaccinations and licensing, because those are absolutely required. You should know that dog bites are not uncommon. The CDC has reported that there are 4.7 million dog bites per year, and insurance thus being very, very important. Now, many homeowners' insurance policies actually exclude dogs from coverage, and so you can get special riders or endorsements or separate canine liability insurance policies. And so if you're getting a dog or a dog owner, you want to check with your broker and get proper insurance coverage to protect you in the event of a negligence claim. Now, if you're on the flip side and you're a plaintiff who has been injured by someone's dog, you want to do discovery into some very specific issues. You want to get all the vet's records from the beginning of time to understand this dog, its history, and how the vet has perceived the dog and what the vet may have told the owner. You want to investigate neighbors to get the facts on the dog history and other interactions that people in the neighborhood may have had with the dog. You'll want to depose all the family members to try to really get at the family's understanding of the dog and interactions with the dog. Now, if you're on the flip side, and you're a potential defendant, well, this goes back to the first point. You want to get insurance, and you also want to, proceed with caution with your dog. Don't allow your dog off the leash when you're walking out in public. Don't let the dog go off leash on your property if you don't have fences up. If your dog has any kind of propensity to biting or its nervousness, you want to use reasonable care. And this is sort of an important issue for a whole realm of class of people: dog owners, businesses with animals on site, businesses that may have service dogs on site, and the like. Now we're going to switch here to wrongful injury or death to someone else's dog. And there's two really important fact patterns to look at. And these were two cases in the California Court of Appeal that were consolidated. The first one involves a golden retriever named Katie who, was taken to the vet, and the vet nicked her intestine. It caused internal bleeding. The vet left some surgical gauze in her body without disclosing it. And this whole surgical mishap caused $4,800 for the procedure and damages and $38,000 in emergency care to save the dog's life. And so obviously what you're dealing with is a family that invested a staggering sum of money for their loved dog, far more than obviously the cost of replacement of the dog. The second fact is a fact pattern dealing with a 2-year-old German Shepherd named Gunner. Gunner gets loose from his property. He goes into the neighbor's property of the defendant. And the neighbors were in a dispute. They didn't like each other. And so this 2-year-old Gunner is on the neighbor's property, and he's at a fence line, and he's barking, and the neighbor's dog is barking back, but there's a fence between them. But nonetheless, the neighbors clearly hate each other because the defendant proceeds to take out a gun and shoot Gunner. And so a vet then had to amputate Gunner's leg. And so plaintiff there wanted $21,000 in vet bills, as well as punitive damages for this just sort of malicious shooting of the dog. So the California court had to now address, what's the measure of damages for injuring a dog? Is it a pure piece of property, so you just get replacement cost, right? Like what's it cost to get a new 2-year-old German Shepherd, a couple $100, whatever it may be, or a new dog in the other example? Or can a plaintiff get a much greater measure of damages, not just cost of replacement, but also medical care, punitive damages, and those types of damages that engraft onto something other than just replacement property? And here it's a very important holding coming from the California court, and this is 2012, and this again echoes the same types of concerns we saw in Oregon. And here's what the California Court of Appeal said in 2012. There can be little doubt that most pets have minimal to no market value, particularly elderly pets. While people typically place substantial value on their own animal, as evidenced by the amount of money we spend, there's generally no market for other people's pets. And so what the court said is, we agree that the determination of a pet's value cannot be made solely by looking to the marketplace. If the rule were otherwise, an injured animal's owner would bear most or all of the costs of medical care required to treat the injury caused by a tortfeasor, while the tortfeasor's liability would in most cases be minimal, no matter how horrific. And so the rule of law, as you see I've bolded there for you, is that allowing an injured pet's owner to recover the reasonable and necessary costs incurred in the treatment and care of the animal attributable to the injury is a rational and appropriate measure of damages. And so what this means is, if you kill someone's $1,000 dog and they spend $30,000 trying to save it, you're going to owe $30,000. You could also be liable for punitive damages. And so it's a massively important holding in terms of shifting, yet again, dogs away from being pure property into recognizing that the relationship of human and dog is different, and that injury to that dog can be compensated in ways above a traditional property market value approach. So our next topic, we're now going to shift from tort law to divorce law. And these are custody battles where dogs meet divorce law. And you see that hilarious cartoon there of the division of community property assets with the house being cut in half and the warring husband and wife, and even the doghouse has been cut in half. And the poor dog's trying to figure out where is he going. Well, it turns out it's not just the stuff of cartoons, it's the stuff of case law. And so, divorce court and division of assets do involve dogs. The general rules regarding marriage property, of course, in our jurisdictions, by and large, is that it's a community property asset, system of laws we have by our various codes. And so, depending upon what the laws say about when those laws attach, property gets split. Dogs are deemed property. And so really, by operation of state law, dogs fall into a piece of property in the marital estate that needs to be an asset and be divided. So this then means at some point in time, courts have been called upon to provide judicial resolution to warring couples over ownership and control and possession of a dog. And as we will see, we'll start with sort of the mid-20th century approach. And this case is just sort of reflective of how things happened in the mid-20th century. And there's a cute little Boston Terrier. And this case is the case of Akers v. Sellers from Indiana in 1944. And there's a divorce. And the divorce decree didn't make any mention of or provision for this Boston Terrier. And as the divorce ended, the assets that were included in the divorce were divided. Husband went his way, wife went her way, and the wife took the dog. And because she had the dog. And the husband then subsequently sued in Replevin. I mean, obviously, there's a bitter story behind all of this. One can be quite sure of that. But nonetheless, the husband files a lawsuit in Replevin saying, literally, the dog is my best friend. Dog is a man's best friend, the husband claimed, and it was my dog, and I want my dog back. And the facts came out, and it turned out that during the marriage, the husband bought the dog, but gave it to the wife as a gift. And so the court applied basically a strict property analysis at root. It's a wonderfully witty little opinion. So if you really want to have fun, just go read this opinion. It's a fantastic, witty opinion. I mean, all the dog opinions, as an aside, are often fantastic to read because courts just have so much fun writing when they get to deal with a different topic like this. But in this wonderfully witty opinion, the court ultimately did a strict property analysis and said it was a gift to the wife during marriage. It wasn't claimed during the divorce as a community asset. Therefore, it's the wife's separate property. End of story. Wife gets it. And that's sort of how it came down. And here's the quote from the court. The court said, "The court, wherein such divorce was decreed, feeling perhaps that the care and custody of the dog of the parties was not an inescapable appendage to their domestic controversy, failed to make any order in reference to the same. And the wife, being left in the possession of the domicile on separation for her husband, just naturally came into custody of the dog." Really great, judicial writing. Now, the modern custody battle approach in divorce court is a little different than a kind of a strict property analysis. The modern trend really is to look at this custody issue through the prism of what's in the dog's best interest. And so this dog's best interest type approach is starting to take priority over a property rights approach. And so here we have a New York case from 1999. And again, great writing from courts, having great fun writing about dog ownership. And here's the quote from this court. "Cognizant of the cherished status accorded to pets in our society, the strong emotions engendered by disputes of this nature, and the limited ability of the courts to resolve them satisfactorily, on this record presented, we think it best for all concerned that, given his limited life expectancy, Lovey, who is now almost 10 years old, remains where he has lived, prospered, loved, and been loved for the past 4 years." Best interest of the dog analysis. This other case from 1981 in Texas involved a really ugly battle in terms of a battle over shared custody and shared visitation rights in the dog. And here we have Mr. Arrington agreed to Mrs. Arrington's custody of the dog if he could have reasonable visitation. He does not complain of lack of visitation, only that he was not appointed managing conservator. We are sure there is enough love in that little canine heart to go around. Love is not a commodity that can be bought and sold or decreed. It should be shared and not argued about. And so there again, the court said, we're not wading into this. The dog's best interest was to have shared custody and visitation. Man it up, basically, the court said. So divorce cases are fun to read. But now let's shift from divorce to police entries. And this is where dogs meet constitutional law. And so as we talk about constitutional law and police and dogs in our homes, we think naturally about the Fourth Amendment. And the Fourth Amendment, as a general rule, protects against any law enforcement entry into the home and prohibits it unless there's a warrant. And this warrant requirement is the cornerstone of the Fourth Amendment at the founding of the Republic. But one of the exceptions that courts for long have been grafted upon the Fourth Amendment is that in the event of exigent circumstances, an emergency of some kind, the warrant requirement is excused. And so the exigency rule is that exigent circumstances, or those conditions that may necessitate immediate action where there's no time to get a warrant, because in the rush of things, a crime or a danger or disaster or some unfortunate event has to be averted on the spot, can lead to a justification to enter a home and deal with a dog. But they don't apply to minor infractions, such as you violate the leash law or licensing ordinance. So if you're violating a leash law and your dog's running around, on your property without a leash and it's bugging the neighbors, the police can't just enter because you've violated the leash law. That violation of the leash law won't give rise to an exigent circumstances. And we're going to look at two cases now to consider with different outcomes. The first case brings us back to Juno, the dog we talked about in the beginning from Oregon, the dog that the Oregon Supreme Court declared was a sentient being in that wonderful opinion from the Oregon Supreme Court. And that case, remember, was a case where there was a police report of dog abuse against Juno, that Juno had not been fed and was in terrible shape and was dying. And so the police came to the house and they knocked on the door, and they could see the dog when they looked in, and they saw the dog was severely malnourished. I mean, physically, it was in terrible, terrible shape. Dry heaving, vomiting, but unable to even vomit anything up because it literally was being starved to death in effect. So the police entered the home under the exception to the warrant requirement on the basis that it's an emergency and we need to get the dog into custody to treat the dog and help the dog, and that then led to the blood test that we talked about earlier. Well, the court in Oregon held that that was an acceptable violation of the Fourth Amendment, and that there was no need for a warrant. That was a legitimate use of the exigent circumstances doctrine because of the severely malnourished nature of the dog and the terrible condition the dog was in. Now, juxtaposing that in terms of the sanctity of the Fourth Amendment in the home is a different case. And this case is a case involving the police getting a report of some animal or child neglect. They come to the house and the dogs are responsive and barking. There's no the dogs physically don't look like they're malnourished or dying, but there's a terrible smell coming from the house. The officer's eyes literally watered up and smarted. The smell was apparently so bad, just from the feces of the dogs. And so the police proceeded to enter this trailer home without a warrant and take the dogs into custody and also the children into custody. And the court there held that actually was an unlawful violation of the Fourth Amendment, that there was no basis to perceive that the dogs, or the children for that matter, but since this is a celiate about dogs, we're just talking about dogs, there was no perception to believe that the dogs were in imminent danger such that they couldn't have gone to a judge and gotten a warrant. Filthy, squalid conditions, the court said, don't justify an exception to the warrant. So the line is somewhat hazy there, right? Squalid conditions aren't enough to say a dog's in danger, but if you physically see the dog in bad shape, that can be enough to excuse the warrant. From constitutional law, we now move to another legal regime that regulates our furry friends, and that's disability law and the law of service dogs. So we start with federal law. The ADA, the Americans with Disability Act, provides that a service animal is a dog that has been individually trained to do work or perform tasks for an individual with a disability. Now, the tasks performed have to be directly related to that disability, but there's no requirement that the dog has ever been put through professional training, so to speak. So the important question under the federal disability provisions is, what does it mean to do work or perform tasks for an individual? And so here's the answer. The dog must be trained to take a specific action when needed to assist the person with a disability. For example, a person with diabetes may have a dog that is trained to alert him when his blood sugar reaches high or low levels. A person with depression may have a dog trained to remind him to take his medication. Or a person who has epilepsy may have a dog that's trained to detect the onset of a seizure and then help the person remain safe during the seizure. That type of training, even if not professionally done, counts as service dog training, and that service dog and the person who owns the service dog is then protected under the ADA from discrimination in terms of entering, places of business and employment and whatnot. Now, the important thing to understand here as we turn to the next slide is that federal law doesn't regulate this area exclusively. It's a creature of dual legal regime of state and federal law. And so we'll look at California as an exemplary state law. And California is good to look at because it's actually broader than the federal statutes. Under California, a California law also, like federal law, prohibits discrimination on the basis of a disability, but it also defines disability broader. So under the federal law, A physical or mental impairment qualifies as a disability only if it substantially limits a major life activity. California, on the other hand, says a physical or mental impairment need only limit a major life activity, not substantially limit. So this difference between substantially limiting in federal and just limiting on the state side is a massive difference in terms of what level of protection is accorded those with service dogs, given since we're on the dog topic. Now, California also provides protection for mental disabilities, including mental or psychological disorders or conditions, such as intellectual disabilities, clinical depression, bipolar disorders, organic brain syndromes, emotional or mental illnesses, or even other specific learning disabilities. And if they limit a major life activity, then California will provide protection. And so what this means is that service dogs under California law can be dogs trained to help people with those types of specific disabilities that may not substantially impair them, but may just impair them, a life ability. And so it's a minimal level to have protection of your service dog under California law, really, that requires you as a lawyer representing, for example, apartment buildings or places of business or fast food restaurants, have to recognize that the preference for no dog rules, for a whole bunch of other reasons, take second fiddle to service rules in many, many respects, given the nature of disabilities. If we turn to the next slide, we can see some specific examples of mental health service dogs in California. And a mental health service dog is a dog that's individually trained to help a person with their mental disability and with some sort of specific requirement to be considered a service dog. If the person does, they're entitled to the same protection as if it was a physical disability or a person with a physical disability using a service dog. So here are some examples of work or tasks that service dogs can be trained to perform with mental disabilities. Waking someone up to get them out of bed to take their medicine, responding to a panic attack by initiating contact to comfort the individual. And you can imagine that occurring at any time of day and in any location. And that person has the right to have their service dog with them to get the benefit of the service dog, helping them deal with the mental impairment. Or even alerting a person who may be exercising poor judgment because that person suffers from bipolar disorder. Maybe they're driving dangerously or they're otherwise acting dangerously, and the dog has been trained to detect and manage when the bipolar behavior becomes erratic and bark or do something. Well, that person too has the absolute right to have their dog with them, and the dog and the person can't be discriminated against. So the next slide, as we get to, the point being there's no doggy discrimination, and you have to be very, very careful if your client is a business owner, for example, that wants to exclude dogs from being in public places. California, again, being broader than the ADA in another respect, provides a broader range of public places covered by the right to have a service dog, and it includes any place to which the general public is invited, including restaurants, hotels, theaters, shops, concert halls, government buildings, medical facilities, hospitals, clinics, physicians' offices, and any public conveyance or mode of transport, airplane, car, train, bus, car, boat, whether private, public, franchised, licensed, or contracted. So all those places you have to allow a service dog on. Now, the service dog doesn't have to be registered, and this creates some complexity and confusion. There's no registration database or certification of it being a real service dog. And so what sometimes happens is that businesses feel, oh, it's not a real service dog, it's people taking advantage, everyone's buying on the internet now, those little cute little red vests that they put on their dogs, and everyone's got a service dog. And so businesses decide, we're being taken advantage of by fake service dogs, we want to exclude the service dog. I want to see a certification or something. Well, as we see on the next slide, the answer to the question whether an operator of a public place can require proof that an animal is a service dog is no. A public place can really only ask two questions to determine if that dog is a service dog. They can ask, is the dog required because of a disability? And they can also ask, what is the work that the dog has been trained to perform? Other than that, your Clients who may not like service dogs coming into their place of establishment can't and shouldn't ask for more because they may trip over the state version of the California version of the ADA, for example, or the federal version of the ADA. One exception to this is that zoos. Zoos, being a zoo with lots of wild animals in them, can demand that service dogs not enter certain parts of the zoo, i.e., it may be not a good idea to have a dog standing in front of a fence with a lion on the other side of it. It may make the lion go crazy. So zoos get exempted from this in terms of service dogs for safety reasons of the general public, obviously. But the practice pointer for your clients is don't wade into it and don't start asking for proof of service dog status. Now, the other flip side, if you happen to have a client or maybe yourself and you got a cute little dog and you like those little red vests, you want to take your dog to work, and so you throw the red vest on and kind of make it look like a service dog. Not a good idea, because pretending to be the owner of a service dog can actually be a criminal misdemeanor in California with a fine of up to $1,000 and maybe 6 months in imprisonment. So if Pooch is not a service dog, leave him at home. Don't fake it. It's a growing issue that's got a lot of abuse. And actually, because the service dog abuse is growing, in large part because it is not a regulated area, so anyone can go on Amazon and buy a service dog vest, basically. That's facilitated abuse, and people love their dogs, obviously, and want to take their dogs to work. That is now spawning this problem, and so actually there's a lot of legislation on the horizon about creating proper registration systems for service dogs to have confirmation of them, so that to get away from this sort of abuse of fake service dogs. Our next topic now we turn to is the issue of hurting dogs, and this is where the criminal law really meets you and your treatment of a dog. And there's a poor picture of a dog that has been damaged and abused, as you can see. And so here's the general rule when it comes to dog abuse or killing. You're not allowed to kill your dog. It's that simple. And so this, again, is a reflection of the idea that dogs are not mere property. I mean, you own your bicycle, you can, in effect, destroy your bicycle all you want, and it doesn't violate any law. But a dog, it's not a pure piece of property. And so the California Penal Code is exemplary, and it simply says, if you intentionally maim, mutilate, torture, or wound a living animal, so it's broader than just a dog, or intentionally kill it, you're guilty of a crime. There's also a complementary rule that goes beyond killing and deals with abuse. And so the general rule is there's a no abuse rule too. Whoever having the charge or custody of any animal, owner or otherwise, so you can be a pet sitter, you subject that animal to needless suffering or unnecessary cruelty, or in any manner abuse the animal, or fail to provide the animal with proper food, drink, or shelter, neglect in other words, or who drives, rides, or otherwise uses the animal when unfit for labor, is guilty of a crime also. And so these are serious criminal violations that come. So the basic rule is no one is allowed to hurt or kill or abuse a dog, period. The next slide deals with dog fighting, which is a corollary to the no abuse rule. And in all states, essentially, and including under federal law even, possession of dogs for the purpose of fighting is actually a felony. And so we can look at the federal law, which is at 7 United States Code 2156, and it's also in Title 18 USC Section 3571. But these laws provide that attending an animal fighting venue is punishable with a fine and imprisonment, as is buying, selling, transporting, or training animals for such fights. So you stop and pause about that. It's an incredibly broad law. It regulates not just the ownership of a dog and the possession of a dog and the use of a dog to fight in a fight, but it also makes it illegal just to be an attendee. So, if you have some buddies who do some dog fighting or something and they say, hey, you want to come watch a dog fight, and you were happy, you actually went to it, you would be in violation of that federal law. There's similar exemplary state laws. It's a felony to own a dog, and this is California law, with an intent to fight another dog, or for amusement or gain, which is the gambling aspect of it, because this is an underground gambling enterprise that often happens. It's illegal for gain to cause a dog to fight or injure another dog, or to knowingly attend a dog fighting event. And so you can see in California, you can get from 16 months to 5 years. And under New York law, it's a felony also, and you can get up to 4 years. Now, let's look at a federal case to see how some of this played out under federal law. Here we have the situation of United States versus Hackman in the 8th Circuit in 2011. And we had a person who had been involved in a dogfighting enterprise. And this person had, been one of the builders of this enterprise. And so they put together contracted fights. They organized the fights. There was wagering of the fights. And the people selected animals for aggressiveness and longevity in fighting, trained the animals to be particularly aggressive and to be able to fight. And then also some of the terrible stuff that came out of this criminal trial was this criminal case was that, dogs that lost the fights were then often abandoned or even just killed because they were then the losing dogs. And so it's really a terribly sad fact pattern for the dogs. And so these people were indicted under these federal statutes and they pled guilty. There was no way out. They pled guilty to this federal charge involving these animal fighting ventures. And the sentence range for the crime was 0 to 6 months, and that was just under federal law for that person with no other criminal history. It was a small sentence, basically, in federal prison for this. But the federal judge that heard this case tripled the sentence to 18 months upon hearing the facts, and on the basis that the cruelty was staggering and horrendous and grave, and 6 months, or 0 to 6, was insufficient. And so took the highest range of 6 months and tripled it to 18 months. No doubt shocked, the people appealed, and the 8th Circuit unanimously affirmed. And so this is a great case affirming the principle that dogfighting is illegal and wrong, but also echoing the judicial rejection, the court's unwillingness to let people get away with this with light sentences, and a much greater willingness to look at animal cruelty or treatment as being the type of behavior that, because they can't protect themselves as animals and that we have custody over them like small children, you will be held to a higher standard. So that decision is prototypical of what's going to happen if people engage in that kind of behavior. Now we move to trespassing, and yes, dogs can trespass, and trespass law has even been a body of law that has found its way into Dog Law 101. And so here's the general rule. An owner is liable for the damage caused by dog trespassing. The prototypical example I pulled here is from Oregon, and this is from the Oregon Codes, and it provides, no person owning or having care, custody, or control of any animal shall permit either willfully or through failure to exercise proper control such animal to trespass or be upon any private property of another person without the consent of such person. This comes from Oregon Codes 4-1-49. Now, the question is, what does this mean in the real world? A dog trespasses off a leash may potentially damage your fruit trees or something if it runs onto your property, and so maybe you have a claim for damages. But by and large, there doesn't appear to be much in the way of damages that occurs by virtue of a dog meandering onto your property. Maybe it destroys some flower beds and there's some damages owed for some new flowers that have to be bought. But it does give rise to the potential for an injunction to force one to comply with the leash laws if there aren't any, or to at least get an injunction to create, in effect, a private leash law for that little area. So it is an important principle in terms of your liability for your dog trespassing. So the best practice pointer if you own a dog or if you have clients in the dog business is, when walking dogs, keep them on a leash so they don't trespass. Now, this then gets reciprocally to, okay, what if I'm the landowner and I don't have a fence up, or maybe I even have a fence up, and a dog trespasses onto my property? What can I do? Well, here's the old rule. This goes from the earliest 20th century and it goes back into the 19th century. And the old rule is that if there's a trespassing dog that's unaccompanied and just comes onto your property, even if it's an unenclosed property, you can kill the dog. That was how the law used to be. The basic holding was that an unaccompanied dog is a private nuisance, and if it wanders onto someone's property, they can just shoot and kill it. Now, the modern rule, again, reflective of the fact that we have shifted away from this kind of caustic property analysis, and we recognize our dogs as being sentient beings that need to be treated differently and more humanely, ultimately. The modern rule in all jurisdictions is that if a dog trespasses onto your property and is just on your property, you will not have justification in killing or injuring it. We saw one of those cases a little bit earlier of the poor German Shepherd that was shot by the unhappy neighbor, and then found himself in massive civil problems with civil exposure in that case, but there were probably also some criminal problems that came out of it too. So don't damage a trespassing dog. All right, so now we're going to turn to our final topic of dogs and law today, and that is dog selfies. And this is where intellectual property law meets animals. And the question, I guess, is that's obviously not a dog in the picture, it's a monkey, so we're almost there, sort of, but we're talking about animals and intellectual property law, because believe it or not, litigation and questions have even arisen as to the intersection of animals and intellectual property laws, specifically the copyright laws in the United States. Now, under the United States Copyright Act, a copyright exists at the moment a picture, for example, is taken and it's fixed in a tangible medium of expression. So if you are doodling right now on a piece of paper, as that pen touches the paper, you've created a copyright in your creation. If you're typing on your keyboard, as the words get imprinted onto the computer screen and the program and all that, you've created a copyright. Paint on a canvas. The same is true for photographs. As a photograph is snapped and it's recorded either digitally or on traditional film, at that moment, on a tangible medium of expression, you now have an original work of authorship. And so copyright inheres in the picture, and copyright belongs to the author of that picture. So if I snap a photograph of you, I've taken the photo, I'm the author of the photograph under the Copyright Act. What does all this have to do with the monkey? Well, it turns out there's a famous piece of litigation that just in 2016, 2017, was litigated out in the United States District Court for the Central District of California. And this is the case involving a monkey named Naruto. And so the picture you saw on that prior page was a selfie that this monkey actually took. There was a cameraman who was out with his cameras and he was working with some macaw monkeys in the wild. And Naruto is a 7-year-old macaw monkey. And the cameraman put down his camera, and the monkey actually picked up the camera, turned the camera around, and snapped the button and took a photograph of himself. And so you saw that really, really cute photograph of the monkey taking a selfie. And so the cameraman was pretty amazed by the fact that this had occurred and the monkey had taken the photo. And so the photograph was eventually released and it made its way out onto a publication about, look what the monkey did type of article. And it picked up some sort of traction in the popular press, and eventually the picture found its way to Wikipedia, and someone entered it on Wikipedia. And the camera owner then contacted Wikipedia and demanded that Wikipedia take down the photograph. The argument being, under the Digital Millennium Copyright Act, photographs that belong to people can't be posted on the internet without their consent. That's sort of the general rule. And so the cameraman said, this photograph belongs to either me or the monkey, and neither have given permission to you to take the photograph, so you need to take it down. Wikipedia stood and defended and said no. Wikipedia said, you, the cameraman, are not the author of the photo. You didn't fix in a tangible medium the photograph. The monkey did. So you can't be the author. And reciprocally, the monkey, he certainly fixed in a tangible medium the photograph, but the monkey can't be an author under the United States Copyright Act, because authorhood under the United States Copyright Act requires a human being. It requires a human to be the one who paints, photographs, draws the poem, whatever it may be, writes the computer code, creates the architectural plans, makes the sculpture, creates the utilitarian design object. All manner of things require human beings under the Copyright Act. And so the camera owner and the people for the ethical treatment of animals disagreed, and so they filed a federal court lawsuit. And this was really a massive lawsuit, and it gained a lot of attention because it was really part of this shifting trend we have about animal rights and about how are we going to, as a broader legal system, view animals and their role in the legal system? And so here we have the legal system now intersecting and interfacing with animal rights. And we're not on dogs, obviously. We're on Naruto the monkey, but it could be a dog tomorrow or a cat the next day. So it's a very, very interesting case still to look at. So PETA and the camera owner file their lawsuit in the United States District Court for the Central District of California. The case gets litigated, and the defendant, Wikipedia, who's sued for copyright infringement, they file a motion to dismiss saying, as a matter of law, the macaw monkey cannot be an author under U.S. copyright law, and so the case has to be dismissed. And the district court agreed and dismissed the case. And the case then went up to the Ninth Circuit, and it was briefed up on appeal, and it was litigated in the Ninth Circuit, but before it could reach a Ninth Circuit panel for adjudication of whether this is a correct statement of law, the case settled, and it was resolved pre-ruling. So as the law stands today, the only published decision dealing with animal selfies is this macaw monkey case coming from the Central District of California, which has held the Copyright Act doesn't apply to monkeys, and monkeys cannot be authors of copyrighted works. And more broadly then, that would mean that animals cannot be authors of copyrighted works. So if an animal creates a work, it cannot be the author of it, and that work won't find protection under copyright laws, which means the macaw monkey photograph is a public domain work. It's simply a work that is not one capable of copyright protection, and so it's by default falls into the public domain. The Ninth Circuit didn't rule on this, of course, but that is the likely outcome under federal copyright law precepts, is that a human being needs to ultimately, or a juridical being needs to be the author as authorship rights vest under federal law. But that's the law today. Who knows? We are in a changing world with artificial intelligence, robots that are going to more and more approximate human behavior and human intelligence or attributes and behavior. And who knows, as that all develops, maybe a robot one day will be allowed to create a copyrighted work and actually be the author of a copyrighted work. And maybe one day animal rights law will catch up, and intellectual property law will also then embrace animals as authors under our federal intellectual property statutes. But until then, the intersection with IP law has been shut down, and animals, including your dog, no matter how cute a selfie he may take of himself or how cute a painting he may draw with his dirty paws running over the piece of paper, no copyright in that creation. Now, this gets to our conclusions of dog law. The case law in various disciplines really is developing. And it's developed in a manner that really is treating dogs as being more than mere property. Case law, as it's developed in the 20th century and is now developing in the 21st century, really sees dogs as sentient beings. And to some extent, this is now forcing all legal regimes, and we've looked at multiple legal regimes today, but all legal regimes really need to adapt and modify those old legal modes of thinking, of just looking at things through a pure property prism, so to speak, and look at them more through the modern way of understanding the uniqueness of animals and and how they fit into our legal system. And this, of course, is really testing our legal precepts, because the core of much of our legal system is that the law and the uniqueness of humans is central to law. And if animals are folded into that, that challenges a lot of the legal thinking that has historically occurred. So it's really a fascinating area of law in all disciplines, whether it's, as we saw in constitutional law, divorce law, property law principles, to understand where dogs fit into our legal regime. The best advice that you can get from this program is to treat your and other dogs well, and recognize that indifference to your dog or another's dog can injure them, and it can lead to liability and exposure. And you shouldn't be cavalier about that. You should recognize that when you saw those California decisions, that is the emerging trend in the law. Damaging someone's dog will not enable you to claim a market value of replacement type damages model, which obviously could be very, very low, especially with an elderly dog or really any dog. Someone may choose to spend $40,000 in medical bills on a $2,000 dog, and you may owe it. So again, the best advice, proceed very, very carefully as you interact and treat dogs. And the final point is that you should be aware that dog law touches all manner of legal regimes, and it cuts across litigation and transactional arenas, as you've seen, with a variety of issues for clients to consider in a whole plethora of legal areas. And so I hope you've enjoyed today this presentation from the Curious Mind Legal Series. It's a fun walk through the park of dog law. There's other fun walks that you can take through different areas of law with our Curious Legal Minds series on these continuing education programs. If you have any questions, as always, please email me, p.afrasiabi@1lp.com. Thank you.